5 seconds to go. Start. For that matter, a convict, that too without following the due process as prescribed by law, in our considered view, it will be totally unconstitutional for more than one reason. Firstly, the executive cannot declare a person guilty, as this process is the fundamental aspect of the judicial review. Only on the basis of the accusations, if the executive demolishes the properties of such an accused person without following the due process of law, it would strike at the basic principle of rule of law and is not permissible. The executive cannot become a judge and decide that a person accused is guilty and therefore punish him by demolishing his residential commercial properties. Such an act of the executive would be transgressing its limits. The chilling sight of a bulldozer demolishing a building when authorities have failed to follow the basic principles of natural justice and have acted without adhering to the principle of due process reminds one of a lawless state of affairs where might was right. In our Constitution, which rests on the foundation of the rule of law, such high handed and arbitrary actions have no place. Such excesses at the hands of the executive will have to be dealt with the heavy hand of the law. Our constitutional ethos and values would not permit any such abuse of power, and such misadventures cannot be tolerated by the court of law. As we have already said, such an action also cannot be done in respect of a person who is convicted of an offense. Even in the case of such a person, the properties cannot be demolished without following the due process as prescribed by law. Such an action by the executive would be wholly arbitrary and would amount to an abuse of process of law. The executive in such a case would be guilty of taking the law in his hand and giving a go by to the principle of the rule of law. It is to be noted that even in the cases consisting of imposition of a death sentence, it is always a discretion available to the courts as to whether to award such an extreme punishment or not. There is even an institutional safeguard in the cases of such punishment to the effect that the decision of the trial court inflicting death penalty cannot be executed unless it is confirmed by the High Court. Even in the cases of convicts for the commission of most extreme and heinous offences, the punishment cannot be imposed without following the mandatory requirements under the statute. In that light, can it be said that a person who is only accused of committing some crime or even convicted can be inflicted the punishment of demolition of his properties? The answer is an emphatic no. There is another angle to this problem. It is not only the accused who lives in such property or owns such property. If his spouse, children, parents live in the same house or co own the same property, can they be penalized by demolishing the property without them even being involved in any crime, only on the basis of them being related to an alleged accused person? What is their mistake if their relative is arraigned as an accused in some complaint or FIR? As is well known, a pious father may have a recalcitrant son and vice versa. Punishing such persons who have no connection with the crime by demolishing the house where they live in or properties owned by them is nothing but an anarchy and would amount to a violation of the right to life guaranteed under the Constitution. This court, in the case of Chameli Singh and others versus State of UP and another, though, was considering an issue in the context of land acquisition. It had elaborately discussed on the right to shelter. It will be apt to refer to the following observations of this court. In State of Karnataka versus Narasimhamurthy 1995 5 SCC 524, this court held that right to shelter is a fundamental right under Article 19(1) of the Constitution. To make the right meaningful to the poor, the state has to provide facilities and opportunity to build houses. Acquisition of the land to provide house sites to the poor houseless is a public purpose, as it is the constitutional duty of the state to provide house sites to the poor. In any organized society, right to live as a human being is not ensured by meeting only the animal needs of man. It is secured only when he is assured of all facilities to develop himself and is freed from restrictions which inhibit his growth. All human rights are designated to achieve this object. Right to live guaranteed in any civilized society implies the right to food, water, decent environment, education, medical care, and shelter. These are basic human rights known to any civilized society. All civil, political, social, and cultural rights enshrined in the Universal Declaration of Human Rights and Convention or under the Constitution of India cannot be exercised without these basic human rights. Shelter for a human being, therefore, is not a mere protection of his life and limb. It is a home where he has opportunities to grow physically, mentally, intellectually, and spiritually. Right to shelter, therefore, includes adequate living space, safe and decent structure, clean and decent surroundings, sufficient light, pure air and water, electricity, sanitation, and other civic amenities like roads, etc., so as to have easy access to his daily avocation. The right to shelter, therefore, does not mean a mere right to a roof over one's head, but right to all the infrastructure necessary to enable them to live and develop as a human being. Right to shelter, when used as an essential requisite to the right to live, should be deemed to have been guaranteed as a fundamental right. As is enjoined in the directive principles, the state should be deemed to be under an obligation to secure it for its citizens, of course, subject to its economic budgeting. In a democratic society, as a member of the organized civic community, one should have permanent shelter so as to physically, mentally, and intellectually equip oneself to improve his excellence as a useful citizen as enjoined in the fundamental duties and to be a useful citizen and equal participant in democracy. The ultimate object of making a man equipped with a right to dignity of person and equality of status is to enable him to develop himself into a cultured being. Want of decent residence, therefore, frustrates the very object of the constitutional animation of right to equality, economic justice, fundamental right to residence, dignity of person, and right to live itself. To bring the Dalits and tribes into the mainstream of national life, providing these facilities and opportunities to them is the duty of the state as fundamental to their basic human and constitutional rights. The right to shelter is one of the facets of Article 21. Depriving such innocent people of their right to life by removing shelter from their heads in our considered view would be wholly unconstitutional. Stop.